Morning, Nina.
Morning,
Whole new
Andrew.
format,
I
hey?
know, how exciting.
God, we've got a tag as we go in and out of the room. And when we do it
Yeah.
between days, I have to wear the same black t-shirt. Frightening.
I know. You should smell him, everyone.
But look, really exciting day today because we're dealing with a whole range of things, but principally with Nina, we're dealing with safety. Nina and I have been out across Australia and we'll be continuing to do over the next few weeks, dealing with psychological hazards and the changes around sexual harassment and gender equality.
Yeah.
That's been exciting training, hasn't it? It's been great response to people. And we're off doing mock courts now, which is always the end of the year to remind people. But can I just say, around the training of gender equality and sexual discrimination, although the legislation is not coming in until next year, this is a good time to be doing because we're running towards Christmas partings.
Yeah, and they're going to expect you to have things in place before, not after.
All right, let's go over to Matt now for the first part of it, okay?
Yeah.
See you soon. Matt,
Yes.
welcome to the couch.
Oh, thank you so much, Andrew. Teleported here.
Yeah, I know, teleported here.
The magic of TV.
Secure Jobs, they're at it again.
Mm-hmm.
So since we last spoke to you, Secure Jobs has passed the House of Reps.
Pass the House.
With the Pocock amendments.
The Pocock amendments.
Yes.
Aptly described.
Yeah,
Andrew.
Burke managed to move 153 of his own amendments to his own legislation.
Yes.
Interesting character.
It's a lot. Yeah.
Driving the wedge between Lambie and Pocock.
That's right.
Hoping that Pocock will take the whole package of Secure Jobs through. I think the chances are almost zero of that happening, but that's a discussion for a later day. We'll know in about 2 weeks' time.
That's right.
But Matt, there have been a number of changes, particularly around the multiple employer enterprise agreement. What are they?
Yeah, that's where we're seeing most of the changes and probably what we're going to see carved out, Andrew. But a couple of key ones, a 6-month grace period after your enterprise agreement expires, if you have a single one, before you can be roped in. Another, if you agree with the union before yours expires, then you can't be roped in. A lot of these changes around really preventing employers from getting roped in, the exclusion of the building and construction industry.
What a great thing
as a whole. It's a big one.
That's the Seeker amendment.
Yeah.
We're not going to deal with the CFMU building construction group at all.
No.
But all of this is to build some form of confidence into the fact that you won't be roped in.
Yeah.
The difficulty is at every stage it allows the union a new gun to point at your head.
That's still
which says,
problem.
well, we'll wait for 6 months.
Yeah.
Or you either agree with us or we rope you in.
Yeah.
It's not good stuff. And I think Pocock's going to struggle with it.
I think he will.
Other one was flexible arrangements, Matt. There was a bit of a change there. Good change, I thought.
Yeah, I think so. Just to clarify that the Fair Work Commission can't, when they're using these new powers to order a flexible working arrangement, can't order an employer to do something that would be otherwise prohibited by an award or an enterprise agreement. So that was one of the big areas of confusion. It's good to know now that, look, they're not going to apply it differently than the rules you already have.
So now we're just waiting until the Senate get hold of it. It's up there with Respect at Work.
Yep.
Respect at Work should get through, I think, without further amendment. There's strong consensus to go through with it.
Absolutely.
The provisions around protection of women that exist in the Secure Jobs, I think, will flow through.
Yep.
So will the contractor provisions, dumb as they are. But I think we're going to see a few hurdles hit when it comes to multiple employer agreements.
Yeah, agreed, Andrew. Yeah, that's going to be the long
well, let's jump to the next one, mate.
Let's do it.
Really interesting. We've spent a number of years where people feel that if you can provide someone with suitable or similar alternative employment, then you don't have to pay the redundancy pay. That's never been right ever since the most recent amendment of the Fair Work Act that says you must apply to the Fair Work Commission. But the McLeod case is an interesting case, but it's really given us some clarity around that, hasn't it, Matt?
It has, Andrew. And what it's really emphasised here is if you want the benefit of this provision to not have to pay the redundancy pay, simply taking passive steps to obtain alternative employment for the employees that you're making redundant is no longer really acceptable.
Look at Chandler McLeod. Look what they did and just explain it.
That's right. So a labour hire provider here loses the contract on a particular site. A new provider comes in, gets that contract, and in that process, the employer, the original labour hire employer, says, oh, well, look, we've got all these employees, maybe you'd like to take them on. The steps that they take aren't very direct. They sort of notify their employees, oh, look, there's this other employer coming in, you might get a job. They send them another email that's got a list of the job openings on the other new employer's website, and there's some sort of very tenuous phone calls that occur.
But it's passive, isn't it?
It's so passive, Andrew. Nothing documented, no promises in writing, nothing that is of any sort of obligation on the new employer to offer new employment.
And then we
to
get the
these
new
employees.
test promulgated, which is the procurement test.
The
isn't it?
procurement test, yeah. So you've got to be able to demonstrate that you've taken active steps and obtained an agreement to procure that work. Not simply enough to say it's out there, but you as the employer as taking steps with the potential new employer to get work.
So it's a
to those
tri-party
employees.
thing.
It
It's
is.
not two.
No.
You've got to have an agreement that between old employer, new employer,
Yep.
and employees,
Yes.
and it must be documented and
Mm.
demonstrated that you're the person,
Mm.
old employer,
Yep.
who procured that outcome
Mm.
to waive it. So that's it, mate. And I'll tell you what, interesting times ahead. I've got Kim next talking about similar sort of
Yeah,
stuff.
absolutely.
The importance of infrastructure.
And documentation. Throwing to Kim.
Well, you can take that to the bank. G'day, Kim. How are you?
Hi, Andrew. I'm good.
Well, we've got some interesting cases today. And what we're going to look at is the importance of infrastructure when we're dealing with managing injuries. We're going to look at it in the terms of termination for people who are dishonest about it.
Yep.
We're going to look at it for possibility of claims being brought. But let's start off with Soanes, the case.
Okay.
Kim, you know all about Yarra-Trams and Soanes. Tell us just two or three of the key facts.
Okay, so tram driver had a stroke at work, had a period of time off work. When he was coming back to work, they had him assessed by a doctor for fitness for duty, but he failed to disclose that he'd had a stroke. Under their legislation or safety standards, anyone who'd had a stroke isn't fit for work for 3 months, and he failed to disclose to the doctors that he'd had a stroke, which meant that they gave a declaration that he was fit for work when he actually wasn't.
And as a result of that, his employment was terminated.
Yeah, because he was dishonest. He didn't make honest disclosure about the nature of his condition. He knew about the safety standards, knew that he was in breach of them.
Yep.
And then when they found out that he'd made a false disclosure to the doctors and they investigated that aspect of it, he wasn't truthful in the investigation.
Okay, so what I want you to see in all of this is, and let's set it across from Zeribus and Mondelez, a very old case, where Mondelez wanted to terminate an old confectioner called Zeribus. There was no paper infrastructure that identified what was the inherent requirements of the job. And when they went to court, they got the inherent requirements from 4 different people. They were all different. And what the judge said in the end, finding for Zeribus, is, yeah, I don't doubt this man can't do the job, but I don't know if there's any reasonable adjustments. So really good juxtaposition. You've got a case here where there's absolute clarity, Soanes, person lies out. You've got Zeribus, a guy who wasn't fit for the work, but wins a case costing $500,000 in legal fees. Simply because the organisation failed to define what the inherent requirements of the job was. And look, that flows into our next case of Borg and Woolworths, doesn't it? So tell us a little bit about Borg.
Oh, look, this is just a lady who exaggerated the extent of her incapacity to promote her serious injury application.
So serious injury application is a Victorian phenomenon.
Yep.
And before you can bring a common law claim, you've got to prove you have a level of liability.
Or disability.
Disability, sorry, yeah.
Yeah.
Okay, so she's lied to get herself over the limit.
Yep.
Tell us what happened.
Her application got dismissed because the judge was aware that she was exaggerating the level of her disability.
But they found that out because the evidence led. They got some CCTV of her wandering around, which showed her disability described was unlikely. They looked at her social media site and saw she was undertaking activities she said she couldn't do.
Yeah.
And then she had all these overseas trips. And so isn't this a good warning again? What do you do when you think someone's wrong? Well, the first thing is, you go to what is the job description and you look at the objective evidence of her capacity or his capacity to do it. Now, that can be shown. Canaan and DP World was where everyone gossiped about a bloke on workers' compensation couldn't do a job. So they appointed an investigator. The investigator found him working on a car and they terminated him saying he wasn't fit for the inherent requirements.
And they lost.
And they lost because the medical evidence was he wasn't fit to do his job. And it's a different issue about the car. He wasn't fit to do the job. So I want us to come home to this very simple issue that Kim and I keep coming to time and time again. The first place you go is the job description. It must be accurate for the job that's being done.
Yeah.
If you're worried someone's not telling the truth, collect the easy to gather evidence to tell you whether it's gossip or whether there's support to suggest someone's being dishonest. Dishonesty in any form of legislation is fundamental to the success in that legislation.
Yeah.
If you lie about a serious injury, you won't get up. If you lie in workers' compensation, it won't be accepted.
Yeah.
If you lie for Fair Work Act, it's serious misconduct and your employment will be terminated. But if you don't have the reliable evidence, you can't do any of it. You're making it up yourself.
That's right.
Thanks, Kim.
Thank you.
So let's get into the new Queensland code that's come through. So they have both regulations and code in
Yep.
Queensland.
Both come into effect 1st of April.
Can I just say, this is typical Queensland stuff. Documentation, documentation, documentation. It is the only code that sets out what controls look like, and those controls are document rich, aren't they?
Yeah, it's really based about what checklists you can fill out, many things. All of their case studies are based around documentation, which is going to be quite problematic, Andrew.
Yeah.
Because as we know, with safety, too much documentation can be a problem because it encourages compliance over looking at the underlying issues and tick box exercises.
And look, this is just, I'm sorry, this is what happens in Queensland. Is safety law gets lost on the idea of a documentary safe process. And I think this code is dangerous. I don't think it's helpful.
Yeah, I think it's going to ignore really the whole point, which is to monitor people. Just because you tick off that they're okay is not going to protect you.
But look, the upside is positive duty is back in there to avoid psychological hazards. So now throughout 4 states and territories, there are codes or regulations that govern this and impose this obligation to actually prevent psychological hazards. But look, let's move on, okay? Because we've got our next favourite case, which is the Dick Stone case. And this is about an employer who never learns a lesson, isn't it?
Literally. We've spoken at length about this case before. So it was meet processor, wholesaler, who was having overseas employees work over 50 hours a week. And they said that was reasonable.
With no choice.
Yeah. And look, court absolutely tore them apart. Despite all of that, at the sentencing
let's say
hearing,
tore them apart under Section 62 because it simply was
unreasonable
expectation of the people to work. Okay.
Yeah, and they hadn't considered the health risks at all. They worked in an area with knives and heavy machinery, so obviously fatigue was a huge risk. But they don't agree.
So when they found the problem out, what did they do?
They gave everyone sheets to fill out whether they wanted to work 38 hours or 50 hours without telling them what the risks were so they could make an informed decision.
And as a result of that, the court fined them over $90,000.
Yeah, it was $93,000.
So can I just say 50 hours work is not an unusual work in our business. It's not unusual. But understanding the risk that comes with it and being clear to people about how that risk is being managed is what this case is about.
Yeah, you need
and
to
if you don't do that, I'm afraid it's all over.
Yeah.
So let's jump to really the meat and potatoes of today, which is looking at the safety regulators targeted directives. I think, Nina, it's fair to say that if we take COVID out of it, when the regulators went into hibernation and just dealt with COVID, what we saw since 2018 was 12 to 14 cases of reckless endangerment and 1 of industrial manslaughter. In the years prior to that, in the whole history of safety legislation, only orbit drilling had occurred before.
It's a massive increase.
And now we've seen this greater focus on the expectations of directors who are not as operational. So all the past cases we're dealing with are operational directors, people. They're people who actually manage the business and are deeply involved. And we're seeing now the focus on those ones who are a little more supine and not involved in day-to-day operations, but ought to know the high-level risks that are occurring.
Yeah.
So if we go back to the old cases, the cases like Carter, which was the woman lifting a car on a forklift, we go back to
like Jackson.
So Jackson's the case I think. I don't want to say Carter for, but Jackson. We go back to all those cases. There's been some really significant jail sentences handed out.
Yeah.
Even in Brisbane Auto Recyclers, a $3 million fine.
Yeah, and 10 months imprisonment.
Yeah. These are significant fines, but the focus now is moving to directors generally. And that's why we're talking about today, because there is a recent case, which is how long ago now? It's only a few months ago that they've started the prosecution in Victoria?
Yeah, I think it's about maybe 2 months, and we don't know the company because WorkSafe won't prosecute it, but it's the first ever manslaughter prosecution against a business in Victoria, and also specifically against the director. Once again, involving a forklift, not surprising. Regulators are cracking down on heavy machinery. And
that's the truth. When we look at what has happened over the last 4 years, heavy machinery, the direction to use it, the system around it, faulty,
supervision,
all those things have led to it. So if there is a high level risk in your organisation, if you use trucks, forklifts and cranes, guaranteed if you fail to follow the codes that exist around it or the proper safety instructions, you will be prosecuted.
Yeah.
But we're also seeing 2 new cases that are coming through, not at industrial manslaughter stage, but around psychological hazards. And that is the new attack of regulators.
Yeah.
So let's just talk a little bit about why is that happening?
Well, why is it happening now as opposed to before? It's always been a focus, but I think today regulators are seeing, look, directors are becoming willfully blind to it. They're relying on things like insurance to say, look, if something happens, I'm protected, but that's just not the case.
Yeah, and when we talk about willfully blind, that's a sort of legal expression that Nina and I are bandying about a bit too much, actually. But what it means is that directors stay in their lane a bit. They come to their board meeting. They're not identifying what's required to, which is how are you managing the high-risk hazards that exist in the organisation. Yep. They're inclined to rely on safety specialists within the organisation.
And not read the safety reports as well.
And some of those safety reports are absolutely impenetrable, 100 pages of graphs, which is also nonsense. So the other part that Nina said, of course, is insurance is going in 3 states. It's gone. It's gone. Illegal to indemnify against it.
New South Wales, WA and Victoria.
And within the next 2 years, it will be illegal throughout all states and territories. So you won't be able to insure for the penalties. You were never able to insure for reckless endangerment, and you were never obviously able to insure for being locked up because they want to go there for you. So when we look at those things, I guess let's look at what you need to do, because that's the big issue for directors. So perhaps I think we've got a slide coming up. Okay, Nina, this is our system that we talk about, and I think the biggest gap you see, so number 1 is a plan.
Yeah, make sure you have a safety plan. If you don't have one, then you're
And where's your independent expertise that says the plan deals with the highest level of risk? I mean, if you're a director and you've got a safety practitioner telling you, have you any confidence that that safety practitioner has the operational skills to give you that information?
Yeah.
So on a regular basis, once every couple of years at least, you must independently bring someone in
to certify it.
Yeah, and say, look, these are the hazards. These are the high level risks. This is the type of control you should be doing.
Yeah.
And then put it into a plan and budget the plan and give it resources, because that is what reasonably practical requires.
Yeah, and actually implement the plan. The amount of times we see people say, yeah, look at my perfectly created plan, but no one's ever looked at it.
So there's no process. Yeah. We don't find the policies and procedures or the safe operating procedures that execute it. We don't
it has to actually be rolled out through the chains.
Nor do we actually see the acquisition of capital that's required in it, so it stays at an administrative control. So implement the process.
I think what you said about budgeting is really correct. Like a lot of times safety is considered as an afterthought, but you actually need to prove that you are, spending the money to implement all the parts of the plan.
And when Nina and I are doing prosecutions, which we've done about 5 or 6 to plea this year, every time the evidence we have to demonstrate is, okay, so this was the hazard.
Yep.
This is how we identified the risk.
We did.
This is the control. This is the resources we put behind it, and the plan and process around execution.
It's the best way to mitigate any kind of prosecution.
And then, of course, as a director, unless you're satisfied you have the plan and process, but the staff are competent at delivering it and do it safely, you're liable.
Yeah, they have to actually understand the plan, because they're the ones on the ground floor. Obviously, as a director, you're not going to be everywhere at once.
Yep.
And if you can't be confident that your staff are competent, then...
So there's one of your key reports that comes out is a demonstration that people are trained and competent in the plan and process. Without that, you have no diligence protection.
Please keep records of training. Like that is something that's so frustrating, because you go through all that effort. If you don't have that record, how will you remember years from now what you did?
And the people who lead people must know what the plan is. They must know the processes. That's their toolkit. They must be satisfied that every person is competent in that plan and process. Now, do you see how this whole thing integrates into a business plan? Because this won't work if the safety plan sits at the side.
Yeah.
After that, how do you check it's happening?
Yep.
How do you do walkthroughs? Do you do inspections? As an executive group or as a board, particularly as a director, where do you have your monitoring process that tells you there is integrity?
Yeah.
If you don't have it and it's not being reported to, you don't have a system. And last of all, of course, you must have a reporting system back against the plan that tells you the success, the gaps, the actions that need to be taken.
So that you can review it.
Yep.
And if it needs to be changed, part of reasonable practicability means you need to change it.
Well, look, that's it, Nina, isn't it? If you're a director, take this plan and test it out in your organisation.
Yeah.
That's our little gift for you today. All right. Okay, Nina, we've got the case study. It's a big one this week. I'm sorry.
Yeah, you got carried away with
I did get carried. It was after midnight. So let's go. You read.
Vicky worked as a draftsperson in the engineering department of Big Build. She was a qualified engineer but chose to do drafting work because of her home responsibilities with kids and husband. She used the SkySieve software to document the structural design created by engineers. Big Build were engaged by large builders and government to develop the engineering infrastructure for large entertainment buildings and shopping centres. They specialised in the structural design for architecturally shaped roofing that was both safe against the worst weather conditions but attractive to look at. Big Build had undertaken a cost-cutting program since COVID, demanded people return to work, and bolstered their engineering team to deal with 4 new contracts they had successfully tendered for. In Vicky's team, there were 3 engineers and 2 draftspersons. Her counterpart drafter was the wife of the managing director. Her name was Sybil. Vicky lived in Craigieburn, had 2 young sons, both school-aged, and a husband who worked afternoon shifts, so she had to be at home on school days for pickups. Her flexible working arrangements had been approved but were not welcomed by her team leader, Jason. Jason was an equal shareholder with the other 8 principal engineers and director. He and his 2 engineers in his team were working long hours to deliver 2 of the new projects, but the documentation process was holding them up. Sybil was not highly skilled and precious. Her husband Dale was a difficult man, and Jason knew better than to push back on Sybil's low productivity. Instead, he increasingly relied on Vicky. He liked her, trusted her, and confided in her his frustration with Sybil. Vicky explained to Jason that her youngest son was starting to develop some behavioural issues, and she thought it came from her inaccessibility and stress from work. It was now common for her to work over 55 hours a week. Her base pay under the award was $32 per hour, and she was paid $42 per hour. Over a year, the over-award payment had previously offset the hours she worked. It assumed an average working week of 45 hours per week. In June 2022, Jason explained to Vicky he will need her to undertake some of the admin work as they had made all PAs redundant. She said yes, but within days noticed some hair loss, her weight had been plummeting, and she felt stressed all the time. One night when she went to bed, she had what she thought was a heart attack. The ambulance came and she found out it was a panic attack. She saw her treating doctor the next day. She admitted she was losing interest in life and couldn't see a way out. She had trouble concentrating and was often tearful when alone. The doctor suggested she take some leave and see a psychiatrist. She did neither, but told Jason. Jason said, "Take care of yourself," but then detailed the mistakes she'd made and said they can't afford any more. As Vicky left work 2 days later, she turned to talk to Sybil. Panic suddenly struck. She lost her balance and fell over the rail of the external stair, falling on her head and dying immediately. So dark, Andrew.
No, so dark, so dark. But, well, I know it's dark, but it's hard to tell stories where people die which aren't dark, is it?
Gosh.
So the first question is, was the allocation of work and method of Jason's leadership a psychological hazard?
Yeah, on so many levels.
In so many ways, isn't it?
Yeah.
You know, when you look at it, so leadership's one part, but the absence of reward.
Poor work design. She was over too much job demands.
Yeah, and then giving her work which was beneath her.
Yeah.
And
not really listening to her when she was saying, "I need help."
yeah.
Just kind of dismissing it. Like, sometimes managers acknowledge but then dismiss. That's also
This is
causing
the
harm.
Birkin and Suncorp. Any reasonable
Yeah.
person at this stage would have gone, wow.
There's a problem here.
There's a real problem here, okay? So, yes, there is definitely psychological hazards, and it's filled with those psychological hazards.
Yeah.
And at common law, Jason and Dale were on notice that this person had a problem and there was a need to intervene.
Yeah.
So the next question is, Jason had spoken directly to Dale immediately after his discussion with Vicky, where she disclosed how unwell she was and said Sybil must take on higher load, explaining Vicky's precarious mental health. Dale had said Jason needed to sort it out and not waste his time. Could both Jason and Dale be liable for industrial manslaughter? Now, I just want to raise this. If Jason wasn't a director, there's absolutely no way, if he isn't an officer, that he could be liable for industrial manslaughter. But Jason is a director, okay? So he is an officer.
Because he's a shareholder.
That's right.
Yeah.
No, he's also a director. He's one of the 8. Now, I forgot that when we were chatting in the car on the way in.
I thought it said he was a shareholder.
Yeah, he's that and a director. No, you've got to go back in the property.
All right.
Gee, I tell you
Making
what.
up facts as you go
No,
along.
it's
I see how it
It's
is.
actually in there. But besides that, and Dale, of course, he's the director as well. He's the managing director.
But he hasn't been negligent with her. Like, in this question, he's raising it directly with Dale. So isn't that doing something?
Yeah, it's not enough. Okay, so if we start at reckless endangerment, so let's build up the scale.
Yeah.
So they're definitely primary duty liability. Could they be reckless endangerment? They're aware of a serious risk to health and safety.
Yeah.
Yes. Could it cause death or serious injury? Yes. Are they indifferent to it?
Indifferent, though.
Yeah. No. But
like just talking about Jason, Dale definitely.
Yep.
But Jason's not ignoring it. Like
No,
just
but
based on this question.
that's the whole problem. In reckless endangerment, taking those acts doesn't get you out. You have to take the right act. Indifference is failing to act in an appropriate way. So a little bit of acting, a little bit of raising it, it's not enough. Yeah, okay. So he's liable for reckless endangerment. The question is, did Dale and Jason were grossly negligent to a criminal level? And I think it would be hard, to be perfectly honest.
It's always hard to meet that threshold for
Yeah, so I don't think that Dale would be, because I don't think Dale has the state of knowledge to be that negligent. He's dismissive and foolish, no doubt about it. He's recklessly endangered someone, no doubt about it. And Jason is trying. So when you see negligence at this level, it is the deliberate disregard. Probably the part that puts Jason at risk is when she tells him how bad she is. He then starts correcting her mistakes in front of her.
Says, I appreciate that, but you're making these mistakes.
So he's on the verge, but he wouldn't be charged. Okay, so let's have a look at the next question.
Has Big Build got an underpayment issue, and could Dale and Jason be prosecuted along with
Big Build? Let's be really clear about this. Unless you've got annualised salary under an award, it's every payroll period is a potential breach. So if you work 42 hours and you're paid enough to pay 45, on those weeks there's no problems. But if every now and again you spike above it, for that pay period it is a breach, and you are charged with each individual breach. So that's the answer to one. Is there is definitely an underpayment issue, and there is now a gross underpayment issue which breaches the prosecutorial guidelines of the regulators, because they say if you look over the yearly period and there is an underpayment, you will be prosecuted. Okay, and you can't mitigate and go to mediation and solve it. Their view is now you accept the plea or they proceed.
And I think both of them actually could be prosecuted as well, because it's unlike safety law, it's not limited to officers.
No, it's not.
So it just depends on their knowledge. So Jason definitely has knowledge about the excessive hours she's working, but whether he has direct knowledge of how much she's getting paid.
And remember, these are the 7 and 11 amendments that came to the Fair Work Act to deal with underpayments following the 7-11 cases of franchises. But let's be clear about the test, because this is a criminal liability. This is not a quasi-criminal liability. This is a criminal liability for wage theft. And that's how this would be characterised. So the reputational damage to this business would be extraordinarily high for being named as a wage theft person. Remember through the restaurant industry how damaging that was. But the knowledge state is, for the managing director, a constructive knowledge, because he leads the business. So he cannot escape it. And Jason definitely cannot escape it because he has specific knowledge. So both of them would be up for very significant penalties for each breach along the way, not just for the one total breach.
But they would round it up under the totality principle, wouldn't they?
Well, they'd use what's called in criminal law the totality principle, which is to work out what the total loss is. But the difficulty with this is this is a criminal provision to prevent repetitive loss. So the totality principle would have a limited play in it. So you would find the aggregational number of it would be taken into consideration. These would be very, very significant fines. There would be back payment. And on top of that, there'd be interest payments. So there would be 3 levels of fines that were involved in this. There'd be the fine itself. There'd be the interest that has to be paid with the back payment. And I suspect there'd be directors' liability responsibilities about their continuation of acting as a director.
I think it would also be widespread because so many other people are doing long hours. So probably even higher fines.
We're going to head off now. Really enjoyed the new structure. And the idea of this is, if there are particular parts of what we're talking about, request them and we can actually send you out the individual parts.
Yeah, we can extract it for you.
And we're really looking forward to it. We're enjoying this enormously and we love having you with us. See you later. Bye-bye.
Thanks. Bye.